We're going, guys. And boom, there we are. Hello and welcome. Good evening to another episode of Reading the Receipts, the weekly update of the Blake Lively Wayfarer court case, providing deeply uneducated analysis on all the court filings that hit the docket this week. I appreciate you being here with me, chat. Happy 4th to all of those who partake. Hi, Marcy Jinx, Obi-Mom Kenobi, Subtle Murder, Gina Richardson, always good to see you. Yvonne Davenport, hi, good to have you in. Aris Wren, and the Junk Farm, good to see you. We have kind of a quiet docket this week. So this is going to be a quick one. I am going to do 2 this week. We're going to do tonight's episode and then another episode on Sunday where I am finally going to get to talk about the amicus briefs and about abuse tactics and what is sexual harassment and especially like sexual harassment in the workplace. What does that involve? Because there's been so many questions about, is what happened sexual assault? Does it kind of sexual harassment, I should say? Does it count as that? What does that look like? Because it still feels like a lot of people are very, very confused about that when I have conversations on it. So as always, we're going to get straight into our disclaimers. We're going to look at some legal documents. Not many of them tonight. Very few. It has been a very busy couple of weeks, and then it's been very quiet this week. But I am not a lawyer, right? I am certainly not your lawyer, and none of this is legal advice. Everything we're going to cover tonight are just allegations. Nothing has been proven in court. Nothing should be taken as fact. This is all just my opinion provided for entertainment purposes only. So, Soul Bliss, good to see you. Bell Moon and my lady, hi, welcome in. Yeah, so let's get into it. So there isn't much, like I said, on the docket this week. So we're going to kind of burn through the docket this week. Junk Farm said you could write a manual on Baldoni. Yes, we could, and we will get there. And, thank you so much, M, for the $1.50 that barely pays me back for the money I owe you for all of the court listener the documents that I keep buying. But good times, thank you. You're our lawyer at heart. No, YouTube School of Law. Welcome into the YouTube School of Law, everybody. And Attica Silva, hi, welcome in. All right, so like I said, very little on the docket this week. There was the informal conference over on the Liner Friedman Talman Cooley docket, which is basically Lively is asking for all of the contacts between Baldoni's law firm and content creators. Well, they had their informal hearing this week and put up the minutes for it, and the minutes just basically say they held an informal discovery conference, and after discussing the motion, the court advised a ruling will be forthcoming. We don't know when. So they heard the arguments for both sides. We are not privy to them. It's held privately. And there will be a decision at some point. We don't know whether this is going to go Blake Lively's way or whether it's going to go Liner's way. I think the expectation is it probably won't go her way. Maybe the judge is going to be very reluctant to allow insight into it. So we'll see. I don't know. I feel like the law firm using content creators as part of their, quote, litigation strategy feels very off, but I don't know. We'll see what happens with that. The other motion that we kind of got this week was Jed Wallace had filed a motion for a protective order to not reveal his client base. So as part of the topics of the deposition, Blake Lively wants to ask about who his other clients are. So Wallace has kind of filed a protective motion to not be able to give that information. They have agreed to move his deposition to the July 9th, which you will probably remember last week was kind of talked about in that tag hearing with Katie Case and Brianna Butler-Kozlow, that they needed those materials ahead of that July 9th deposition. So now it's been revealed that that July 9th deposition is scheduled to be Jed Wallace. He says that, there's certain topics that are an impasse and was requiring Street to identify the names of its entire client base from the 2023 to now. Street seeks protection for being required to identify those names, and that sharing those identities would be harmful and an undue burden because these are clients, from famous individuals and companies to private citizens, who've relied on Street to perform crisis management services. These services are highly confidential and sensitive. They range from coordinating substance abuse, addiction, and mental health treatment to other specialized crisis response coordination. Street's clients rely on being able to seek help privately and without fear of disclosure. This is why Street agrees to confidentiality with each one. Who Street served is not relevant to any claim in Lively's complaint, and Street has already testified that it did not, in fact, engage in the type of conduct alleged here. In our conferences about how this discovery could be relevant, Lively described it as part of her hope to find, quote, the existence of any pattern in the profile of customer services and online discourse surrounding such customers that could be directly connected to Street relations. In other words, Lively is fishing for indications that Street's representation of other clients looks like what she thinks happened here, but did not. The absence of probative value weighed heavily against privacy concerns warrants this court's intervention. Given Lively's explanation, an attorney's eyes only designation is not sufficient because any disclosures would violate the trust that Street's clients have placed in it and would not shield those clients from future rounds of the type of far-reaching and public discovery employed by Lively to date. The attorney's eyes only designation, remember, was like a big discussion at the beginning of this case about whether there would be a presumptive one or whether you would have to ask the court for one. And what that essentially means is it would only go between the attorneys. If it was relevant, then they could seek to have that designation removed or lowered so they could actually use it in the trial and in court and share it with their clients. Street explained these concerns when the parties met and conferred on June 16th and followed up by email until June 18th. Now, keep in mind, he's talking about this on June 18th. It's now July 1st. So this has taken almost 2 weeks for Jed to kind of raise an objection here. Street has agreed to identify his clients by category: filmmakers, actors, private citizens, and even more, Street has agreed to testify about the services it provides for its anonymized clients. Lively has rejected this compromise, pursuing instead her wide-ranging search for facts that she implicitly acknowledges may not even exist. But it has long been ruled the court in the circuit that the parties should not be permitted to roam in the shadow zones of relevancy, which amuses me greatly. The idea of like, you have been banished to the shadow realm, which I don't know, is that where Jed operates? I don't know. I thought it was outside of Austin, but Street may have coordinated crisis management assistance for other individuals and companies, but the identities of those non-parties do not have any tendency to make Lively's facts more or less probable than it would be without those identities. Disagree. Again, I think, if there's a pattern of behavior here, which is what we all suspect, then it would actually make her alleged facts more probable. If Jed has represented a number of clients who've gone through exactly the same sort of multi-pronged smear campaign and social media assault that she's alleging that she has gone through, then yeah, it would make it more likely that, if every time Jed shows up to quote unquote help manage a crisis of a client, that there's this media storm around it and all of these fake social media accounts show up, then yeah, like if you are always at the scene of the crime, like, begins to raise some questions. My lady says he's in the basement next to the water bottles. Bobby Mom says, identifying clients is the same as identifying what you do for the client. Yeah, exactly. And identifying what that client needs. Street is willing to testify about his activities and engagement as it relates to the complaint, but it must protect other clients' identities where it does not. They just basically go on to say, Lively is only entitled to discovery relevant to her party's claim or defense, and that discovery must be proportional to the needs of the case, which he argues it isn't. Because of the lack of relevancy and the sensitive nature of Street's business, the identity of Street's clients not connected to this litigation should not be discoverable at all. It also goes on to say, not to mention further disclosure could damage Street's future business because of this needless violation of trust, which I feel is interesting because if you remember, part of Lively's argument in the motion to dismiss was arguing about that, Wallace needed to keep his business secretive and anonymous, and that was really where his objections were around. It wasn't necessarily like the defamation wasn't necessarily around being defamed or being tied to this sort of campaign. It was his ability to be able to do it anonymously that he was worried about being damaged. And yet here again, he's sort of reinforcing Lively's own argument that if he is forced to disclose client lists, that would damage his future business because he needs to do so in a very anonymous and confidential way, which interesting because again, like, I mean, Lively has Jed Wallace's former attorney on board, so I feel like a lot of that information would probably already be known. Street respectfully asked the court grant this letter motion to protect Street from having to disclose any name in its client base beyond those identified as parties in Lively's complaint. Lively had already responded. Oh, sorry, he includes the email chain. Someone says, in the business of destroying other people, but has a complaint about being damaged. Yeah, I mean, this is the frustrating thing, right? He's in the business of, allegedly, doing these massive smear campaigns and going after people's reputation, and then at the same time sort of pleading poverty to the court about, well, you know, my reputation is so important that it can't be damaged in this way of it being known that I had to disclose my client list, because just knowing that I disclose my client list, even if it's done with attorney eyes only, even if it's done to the attorneys and none of those names are ever disclosed, just the knowledge that I participated in that would be damaging to my business. Like, yeah. So anyway, they provide the email exchange. Green is Wallace's response, where Kristen Bender is talking back to them and saying, here are the topics, right? You indicated the inclusion of client base for street relations may be problematic due to the confidentiality of those relationships. And you further indicated that designating the transcript as confidential or AEO would not resolve those concerns. Customer base of street relations highly relevant to Lively's allegations of conspiracy in the ongoing campaign against her, as it is likely to demonstrate inter alia the existence of any pattern in the profile of customer services and online Discord, right? Which we just said, right? There's a pattern there of your customers all suddenly have these massive online smear campaigns directed against the people they are being, you know, they want to target. Then yeah, if you're always at the scene of the crime, that begins to be suggestive. That can be directly connected to street relations. This information is particularly probative in the light of street relations and Jed Wallace disclaiming virtually all involvement in the digital campaign allegations by Lively. Our review of applicable authority demonstrates the disclosure of customer information is generally permissible, even where otherwise confidential, especially with the confidentiality designations we have suggested. Given the questioning will focus on customers over a limited time period, and given that we are able to identify no discernible potential harm from the disclosure of this highly relevant information, we do not see a basis for limiting disclosure. So they're going to say that the identities of street relations customer base from January the 1st, 2023 to present. So this is their response. I first said that our view was the names of street clients were irrelevant to Lively's claims. That's why Lively needed specific names instead of descriptions of the types of clients by category. As examples here, filmmakers, actors, private citizens, dog catchers. Feels like a very specific and odd example to throw in there. I don't think he does actually represent dog catchers. Not aware of any dog catchers who can afford $30,000 a month to basically have somebody watch Reddit on their behalf. But yeah, I think he's just throwing that in there. It's a random job occupation to point out. And as I pointed out, that Street would testify about the services it provides. It seems from this explanation that Lively wants to conduct discovery into Street's clients, none of which are named, mentioned, or otherwise called into question in this lawsuit, because she would like to piece together something that she thinks looks like what she alleges, lots of little brackets and parentheses here, happened here. We do not agree to open Street or its clients up to this type of phishing expedition. Customer lists may be discoverable in other contexts and with other aims, but we do not see how they are discoverable in this case. Given this explanation, it appears to us that no level of confidentiality designation would protect Street's business from the harassing and burdensome nature of Lively's plan. This is interesting to me because I feel like, I don't know, let's talk about it after we get to Lively's response. We'll do Lively's response first. It's like when my lady says, it's like when Mabel and Nathan complain about the backlash to their actions when they're in the business of causing backlash to people for minor faux pas. Honestly, it's wild that all of the PR people being really mindful of like, but my reputation, like you spend all day dragging everybody else. Like, and we'll get into that a little later when we talk about the subpoenas as well with the content creators, because yeah, very much the same sort of argument of I want to be protected from the consequences of my actions. Obi-Wan Kenobi says, "Oh, now we're worried about protecting reputations." Yeah, well, just my reputation. Everybody else's can go to hell, and I will burn it to the ground. But my reputation is sacrosanct and cannot be infringed. Atticus says, "All employers should know their client list may be disclosed in a court of law following due process." Yeah, all right, let's get into that then before we get into Lively's. I mean, the whole point of the discussion, if you remember back in February, about the AEO designation and why it was needed, or why there was this presumptive AEO, right? From Jones, well, I don't know if it was just from Sloan and from Lively's side at least, because I don't think Jones was on that call, was that, you know, they work in PR. And as part of the discovery, stuff like client lists, stuff like business plans would come up, and they needed that AEO designation to be presumptive without having to go to the court first, because they fully expected that client lists would be discoverable in this lawsuit. And in order to protect that, they wanted an AEO designation so that those could be, you know, just shared only with the legal team, not with the clients, because there was a fear of those being leaked. And that if there was relevant or pertinent information in those client lists, that they could then go to the court and try to argue that that information could be disseminated and could be used in court. And, you know, Judge Lyman had said that he would be open to granting an AEO order for discovery, but that AEO protection would probably not be there when it gets to trial, right? And they would have to figure that out. And unfortunately, that would probably mean any relevant, protected and confidential information in discovery that was going to be used in trial was probably going to end up in public. And that would have to be a discussion coming down. But this was exactly the point of that discussion, was that client lists were discoverable. I don't know that Jed here makes a compelling argument of why his specifically shouldn't be, other than kind of saying, well, it's sort of tangential to Lively's claims. But I don't know how any client list in this case, right? Whether it's the client list of Stephanie Jones, whether it's the client list of Leslie Sloan or of Melissa Nathan or of Jennifer Abel, which was the context of that original conversation, I don't know how any of those are directly relatable to the claims in this lawsuit. So I feel like this whole idea of having client lists being shared, even though they're tangential and not like directly related to the main claims, we've already discussed and said that was fine. So we'll see. I don't want to like make a prediction on this one because I don't know which way it goes, but I feel like we had this conversation. This is why we have AEO. And I feel like Lyman's decision here might be exactly along those lines of the whole reason you have AEO is so that you are not filling my docket full of these types of letters. So I don't know. And we will see why. Dog catchers are worried about Reddit. Yeah, I mean, dog catchers are very worried about their social standing on Reddit. So Lively has responded, basically saying that, look, you know, the client base is directly relevant. You know, she's bringing claims against him for a social manipulation campaign, and that he alleges to specialize in executing confidential and untraceable campaigns on social media platforms to shape public perception of his clients and their adversaries. Wallace is alleged to have previously worked with the defendants Tag and Melissa Nathan, a relationship that Tag admitted in connection with Lively's initial complaint. I will say, there is somebody on Twitter, I'm not going to mention by name, but they will probably know by this reference, who took this and was like, oh, Lively is alleging that Wallace previously worked with Tag and doing so off no information. She's got no evidence for this. And it's like, you clearly have not been keeping up with this case, because Tag very much admitted that they had already previously worked in them. In the initial answers to Blake Lively's original complaint, before she amended it, answer 156 that Tag gave to her allegations about them working together previously, Tag said, defendant admits that Jed Wallace had worked on previous matters with Nathan and was retained by Tag on behalf of Wayfarer and Mr. Baldoni. As to remaining allegations, defendant lacks knowledge. Tag admitted it. Now, I will go back and say, when it came to Lively's amended complaint, Tag did change their answer and say, oh yes, we previously said this, but we were wrong and we don't know anything. But as we've seen from the emails, we know that Jed Wallace was retained by Wayfarer in this case. He sent them the invoice, he sent them the W-9. So they paid him, they paid the taxes, and made sure that the money went to his, what's it, tax number? I forget what it is, EIN? I forget. But to his business's tax number. So in that sense, like Wayfarer retained him, not Tag, but they did admit previously that, yeah, they worked together before. And I think that's shown a lot in like those emails as well. Did I copy those emails over? I didn't. I don't think I did. But in the emails between Jed Wallace, actually, we just bring it up. Why not? We got plenty of time to kill tonight. We're going to burn through this super quick. It feels nice to actually have a reasonably slow docket this week, which means next week is going to be insane because I am bragging about how slow the docket was this week. I remember that it was 300. Was it 300? I say that it was 300 and it's not 300. Oh. Redaction. Keep going. Redaction to 300. 347. There we go. So in these emails, you know, Nathan is, you know, showing that they have like this relationship, showing please meet Jed. You know, Jed and his team has worked on, like, there's clearly some knowledge and prior working relationship. And then Katie Case in particular comes on and says Jed and his team are truly some of the best. Not a conversation you would have as if this is the first time that you guys had all worked together. So very clearly, and I think isn't this where he calls them family as well. So very familial from Jed in this situation. So definitely feels comfortable. So anyway, getting back to all of this, they had previously admitted that. Oh, I just need to read a little further. Here we go. Tag admits that Jed Wallace had worked on previous matters with Mr. Nathan and was retained by Tag on behalf of Wayfarer and Baldoni. Along with Wallace, Street is alleged to have been a key part of the social manipulation conspiracy to bury Lively and advance a negative narrative by seeding and manipulating content on social media and internet chat forums like Reddit, TikTok, and Instagram. Client information is relevant to Lively's ability to understand and prove the nature and extent of the social media tactics used in the retaliatory and conspiratorial scheme against her. Learning the identities of Street's clients for the limited period of January 1st to the present will, for example, allow Lively to evaluate those clients' online profiles and identify digital patterns by aligning with those deployed by the Wayfarer parties in their untraceable campaign against her. By way of example, preliminary public digital assessments report strong indicators of inauthenticity in connection with the online narratives regarding Lively in August of 2024. And I think, is that going to be the, misogyny slap ecosystem where, you know, social media data analysts said that like more than 80% of the social media posts were inorganic. I've forgotten the link, I should have pulled it up, but there was a second analysis that was also done about the media stuff around it. Actually, I can pull it up. Let's see if I can pull that up as well. If you'll give me a second. Let's see what chat's saying while I try and pull that up. I'm just clicking around all over the place and getting things wrong. Atticus Silva says trade secrets, existence, management of bot farms, untraceability, clients who have been played against each other without the other's knowledge. Jed's relationship with Friedman, repeat business. Yep. Yet Friedman didn't want to accept service for him. And like we talked about, his business was, when it was registered over in California, was registered to Friedman's law firm. All scientists said also conveniently cut off the email with the details of when they worked together. Yes. We worked together. Now, I believe it's in production, right? Like, I'm sure Jed Wallace didn't just produce that one page, and I think it's numbered to where, you know, it's one of a number. So Lively likely has the other pages and just deliberately cut that off to protect him a little bit for right now. um, let's see. Let's see if I can find this other one, because like I say, there was a second article where they had talked about this. So this. Here it is. Oh, I gotta scroll up, find it. Yes, there it is. Okay. It was this one. It was an article by Fast Company that was just talking generally about bot farms and bot farm patterns of behavior. And then let's just go to Baldoni. I can't connect it to Baldoni, but I can say there is evidence of synthetic activity that is not human, said Ori Lee Harvey, an independent threat consultant who analyzed the Lively Baldoni incident on XPOS. The analysis showed that the bot farm application activity had been coordinated against Lively. Preemptive search in coordinated inauthentic bot-like activity that they found came around on December 20th, a day before the New York Times broke the story about the Lively allegations. And I believe that also ties into the Trolltoll guy who kind of came out and spoke out and said that they had been hired proactively to look for these search terms before all of this stuff started. So they knew it was coming, and then they saw a spike in bot activity and inauthentic social media engagement as a result of it. So yeah, it's relevant entirely because if there is that same pattern in amongst other Wallace's other clients, then yeah, it looks like, you know, again, if he is always at the scene of the crime, good to go. My lady says, I have to go to therapy now. We'll probably not be here when I return, so I wish you a good stream. I appreciate it, my lady, and good on you for prioritizing yourself and your needs, and I hope you have a good session and it's productive as you go through that. So I definitely always find it a useful and helpful conversation. All right. Because tracing those back to the originator is difficult, the ability to identify instead social media users' accounts that did not just participate in this campaign, but also in other campaigns for Street's clients would allow identification of inauthenticity as to Lively's attributed to the defendants. I think that might be a little bold. I don't necessarily know that you're going to see the same accounts, creators, different story. But like Reddit accounts and TikTok accounts, I don't know that you would see that, but that would be interesting to know if those same accounts just showed up again and again for his other clients. A scientist says, oh, look, another convenient coincidence where what they wanted to happen happened without them doing anything. Yeah, it's just, you know, all these bots showed up on the day before and we don't know what. Masajik says, I'm back from the walk. Good to have you back. Hopefully it was a good walk. You got some good exercise in. Obi-Wan Kenobi, if I did this crapola all the time, I wouldn't want to release my client list either. Yeah. Agreed. Among other things, the information would be highly relevant, circumstantial evidence of what the Lively parties did, what the Wallace parties did in this case, as well as relevant circumstantial evidence of what the other Wayfarer parties who were familiar with Street and Wallace's work sought to achieve by retaining them, right? If they have examples of his work from before, they knew what they were trying to get. Merely identifying Street's clients by category would be insufficient to meet this need. Likewise, knowing what services Street provides to specific clients in partnership with other defendants like Nathan will assist Lively in discovery as to her civil conspiracy claims. All this satisfies the extremely permissive deposition discovery regime applicable here. Street's principal argument is to again cite Wallace's own self-serving testimony during his participation, disputing his participation in the conspiracy. As at the motion to dismiss stage, he asks Lively and the court to trust his word that he didn't do what the amended complaint alleges. Which, as we already said, that word has been bent very significantly by what he's already handed over in discovery, where he says, essentially, you know, I didn't have this type of team, I didn't do any of this. And then he, in the emails, is talking very much about his team. And so it seems very much that while he may not quite have perjured himself, he's definitely generously treading the line of bending the truth a little bit. Ultimately, it will be up to a jury, not the Wallace parties, to decide whether to believe Wallace's self-serving testimony in light of the evidence. By putting his credibility in issue in this discovery dispute, Street has only confirmed the relevance of the requested discovery, because the client information would assist Lively's efforts to test Street's assertions and Mr. Wallace's credibility. I think that's a really good point, right? Like, he's arguing, hey, you can trust me. I didn't do any of this. And Lively's like, great, well, then you can turn over your client list and you can prove that, right? Like, you want to put your credibility on the line, and really kind of state that you didn't do this, then put up and shut up, or shut up, essentially. So Street has not established a good cause, doesn't satisfy its burden to for a good cause for a protective order. Street claims that sharing the identity of his clients would be harmful and an undue burden because its services are highly sensitive and confidential. The Street has agreed to provide the requested testimony on its services and has not shown any particularized facts demonstrating harm from disclosure of its clients to Lively in this limited context. I think that's also kind of a bit off. If, he's saying that he can't disclose this stuff, but then also, yeah, I'll tell you what I did and disclose the services, you're already admitting that there isn't any real harm from disclosure of exactly what it is you do. Further, although Street asserts it agrees to confidentiality with its clients, private confidentiality agreements do not preclude discovery in federal litigation. Accordingly, Street has not demonstrated a particularized harm or undue burden that overcomes Lively's need for this relevant information. Obi-Wan Kenobi says, very telling he's worried about his reputation simply by the release of his client list. And seriously, trust me, bro? Yeah. I mean, this has been Wallace's entire argument has just been, I didn't do it and you can trust me. I wouldn't say that I didn't do it if I didn't actually do it. And then goes on to basically say, look, the protective order already provides sufficient protection, that he can invoke attorney's eyes only. And, we already did that because of any trade secrets, confidential business plans, marketing plans, and strategies for clients other than parties in the litigation. Street's assertion that an AEO designation will not be sufficient because any unspecified disclosure will harm Street and its clients based on future discovery by Lively from these clients is conclusory and speculative. But such discovery could only proceed if it was relevant to Lively's claims, something that no party can prejudge before the client information is disclosed and would likewise be afforded the protections of this protective order. I thought this was a good argument because, Wallace is basically saying, I don't want to hand over my client list because Lively could go after them too. Lively makes the point of, I could only go after them, right? And continue discovery and litigation against those clients if it was relevant to my claims. So that fear would be justified only if that information is highly relevant to me, right? That fear and that threat doesn't exist if your client list is of no use to me, is of not any relevance, which is what you're claiming. The only way that I could continue to litigate and go after your clients as well that you're fearing so much is if it was entirely relevant. I feel like that's a good argument in terms of disclosing this and handing this over, personally. I'm sure hope that Johnny Depp isn't revealed as a former client. Well, this is from 2003, so I don't know when, January, right? I forget when a lot of that kicked off, right? I'm sure some of you in chat already have that burned into your head. When was that? The Virginia trial was June 2022, so that would predate this. So unless there's an additional stuff afterwards, this would predate that case. I think it's Brad Pitt and Sudeikis. Maybe. We will not know. I think it's just going to be a long list of dog catchers who have been really just harmed by mean people on Reddit. So yeah, so that got argued. I forgot there was one other piece that did get put on the docket this week, and I forgot totally about it. Where is it? July 1st, right? It was Lively's letter. Where's Lively's letter? I forgot about this. So the judge had also ordered that both Blake Lively and Jed Wallace issue a letter of 2 pages responding to the argument of tying Jed to the conspiracy to actions or acts that happened in New York. Solely says, what's it, unlikely, perhaps a little bit too much to hope for, but imagine the impact that would coming out from having amongst common folks and thankfully increasing or waking up to the awful. Um, Possibly. And I think this is another thing that to talk about is like we are so deep in this, I think, in being involved in this, uh, that we might have a little blinkers as to how this case is seen and viewed by everyday, people who are not sat here F5ing on court listener most of the day or trawling Reddit. So uh, I don't know. I don't know if any of this changes this. I think for most people, they will pick this case back up when it goes to trial. They're not obsessing over every filing that happens. I think that is a very select few of us on both sides. So Lively has filed her letter. I think Jed has until the 7th or the 5th. So I think he's got a little longer to file his letter in response. So basically, Lively alleges that the amended complaint identifies numerous specific co-conspirators who committed overt acts in furtherance of the defendant's conspiracy while physically located in New York. As just a few examples, the amended complaint alleges that defendants Baldoni, Heath, and Wayfarer heard from Lively in person in New York about the very complaints that prompted the retaliation campaign. So, she reported them while on set in, I think, New Jersey, not quite New York. But then also, they had the meeting in her penthouse, which I think is in New York and stuff. That those defendants engaged Jones Works, a non-party co-conspirator. So Blake Lively here, I think, for the first time, kind of alleging that Jones Works is a co-conspirator in all of this, with a physical presence and a principal place of business in New York. That Melissa Nathan lived in and conducted business in New York during a portion of the relevant period, and that Sarowitz announced the conspiracy's plan to ruin the lives of Lively and her family at the film's New York premiere. The amended complaint also alleges that Nathan, among other co-conspirators, furthered the conspiracy by communicating with journalists, content creators, and media entities based in New York, including at least one journalist at the New York Post and another at the New York Times. I don't know if that's new information. I guess not, because it's a quote, right? So I guess that must have come from the amended complaint. New York Post isn't surprising, right? Because it says there, one of whom was Nathan's sister. We knew that Sarah Nathan works at the New York Post / Page Segs. Not sure who the New York Times reporter is that they were talking to. And was that before they got all of the complaint and everything? Be interested to know more details about that. I don't know if you guys... if I've missed something or you know what that's referring to, but I would be interested to know what New York Times reporter. Given that Nathan lived in New York during a portion of the relevant period, it's reasonable to infer that Nathan conducted much of that activity, each instance of which would constitute an overt act, while physically present in New York. So if every single act counts, then Lively saying, well, while she's in New York, there would be multiple acts performed by her during it. The New York contacts are easily attributed to the Wallace defendants for purposes of motion to dismiss stage personal jurisdiction analysis. The amended complaint alleges that Nathan and Tag had a relationship with Mr. Wallace that preceded the litigation, and that Nathan worked with Wallace on previous matters, and Tag retained him to work with them on behalf of defendant Wayfarer and Baldoni. It is reasonable to infer that Wallace knew that Nathan resided in New York, or at least that she had resided there during a portion of her participation. That is sufficient to attribute Nathan and Tag's New York-based acts to the Wallace defendants under both New York and federal law. New York's broad approach to agency attributes long-arm statute contacts to co-conspirators when A, the defendants have an awareness of the effects in New York of the conspiracy's activity, B, the activity of the co-conspirators in New York was to benefit the out-of-state conspirators, and C, the co-conspirators acting in New York acted at the direction or under the control or at the request or on the behalf of the out-of-state defendant. I don't know that part of it. Is it all of those that have to be true? That the defendant had an awareness of the effects in New York of the conspiracy's activity seems fine. The activity of the co-conspirators in New York was to the benefit of the out-of-state conspirators. Yeah, sure. He's going to benefit by getting paid for it. That seems fairly obvious. but the co-conspirators acting in New York acted at the direction or under the control or at the request or on the behalf of the out-of-state defendant. I feel like that worked the other way around. Maybe I'm missing something. If I'm missing something here, chat. Yeah, Massey Jinx says, I think or means either or. Well, it says and. It says and right there. And see. All right. The Wallace defendants have never contested the first two elements, nor could they, because the amended complaint alleges that Wallace knew the co-conspirators included New York individuals and entities who were taking steps in New York to retaliate against Lively. Okay. The Wallace defendants were paid for it. Yep, like I said, they get paid for it, so that's number two. All right, so what's third? The third requirement that New York-based co-conspirators acted at the direction or under control of the out-of-state defendant may be satisfied by an allegation that the out-of-state defendant was aware of the torts being committed by the co-conspirators in New York. Ah, okay, that's the piece I was missing. So he doesn't have to be directing them. He just simply needs to be aware of the torts being committed by the co-conspirators. In other words, New York courts do not mandate a showing of control or direction. Okay, just need to read ahead a little bit. Okay, see, now this makes more sense. Okay, now, yes. Miss Lively alleges more than knowledge. She alleges that Wallace defendants participated directly in the scheme being executed by, among others, the New York-based co-conspirators. Yeah, gosh, I should bring up Wallace's email back up again. What was it, like 300, I think because it's very clear he's aware of why and everything. Because he says in here, while the circumstances are the circumstances, this is our wheelhouse. So this seems to suggest, and again, we don't know without the rest of the conversation, it seems to suggest that Jed understands the situation that is going on, that it is probably related to that fear of those sexual harassment allegations. And if so, then that would satisfy what is needed here, at least I believe, right? That seems to be the case. But I think also just knowing that they were committing a smear campaign or trying to direct hatred or damage Lively's reputation, I think would also match, even without knowing about the sexual harassment. Not a liar though, so maybe not, but that would seem to be enough. To be clear, however, conspiracy jurisdiction over the Wallace defendants is also proper under another New York long arm statute, something the Wallace parties never challenged in their opening brief. Although they challenged the application of this long arm statute to their individual activities, the Wallace defendants nowhere challenged the sufficiency of other co-conspirators' jurisdictional contacts under any provision of the New York long arm statute. Nor did the Wallace parties challenge the attribution of their co-conspirators' conceded contacts to themselves under the cases in which they later cited in reply. So they're saying it applies to the other parties, and since they have contact with them or working with them, then it would also extend to them, I guess. Wallace defendants' silence as to their co-conspirators' contacts was enough to establish statutory long-arm jurisdiction over them. In any event, the co-conspirators have extensive suit-related contacts with New York that must be attributed to the Wallace defendants. Blah, 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 blah. Each of those contacts must be attributed to the Wallace defendants under the long-arm statute and federal due process principles. And then we just sort of end. Okay. Usually there's a wrap-up, but I guess we were really just kind of trying to take every last piece of those 2 pages. And so there is no conclusive statement at the end to say, therefore, give me what I want. Just done. Signature on page 3. Call it a day. Any defects as to the allegations of personal jurisdiction with respect to Wallace parties would be curable by amendment based upon materials aimed at discovery. Hang on, we've seen this story before. I seem to remember this all throughout Wayfarer's responses to their motion to dismiss. Look, if you think he's convincing, we'll just fix it. We promise we can totally fix it. So that's kind of a treat. That's kind of an Easter egg to see from Lively that we're getting that. We're getting callbacks now. We're getting in-jokes in there. This is how deep and tragic this is all becoming now. We're finding in-jokes in legal documents. On behalf of everybody, chat, we all need a hobby. We all need some sort of hobby outside of this. But yeah, that's funny. Including from Wallace. They got additional discovery from him. Those additional allegations would relate to the nature and timing of the Wallace defendants' retention. Ooh, including information shared with the Wallace defendants and the nature of the timing of the co-conspirators' activities in New York, including Nathan's maintenance of a residence in New York. Interesting. So they're saying that as of discovery, they've got extra information that Wallace knew about what was going on, the nature and timing of the Wallace defendants' retention. I think we already kind of knew about the timing. I don't know why that's more, unless it's to do with more information specifically about being hired in response to people speculating about the feud. Maybe that's what that's referring to. But information shared with the Wallace defendants and the nature and timing of the co-conspirators' activities in New York. Interesting. I kind of want her to lose this now and see the amended materials that are going to be put into it. Just because I'm greedy for all of the discovery we can get. Jed should start a 25K a month, what not to put in writing course. I mean, all of them should at this point. I mean, rule number one, very easy. If you have to say don't put this in writing, then don't put it in writing. Just stop right there. Don't even don't put it in writing. Just I mean, it's funny because there is a couple of places where they're like, I will call. I'm not going to read that. I will call you, right? And they know that I'm not going to text message this. So it's interesting that in other places they forget about it completely and they're like, no, we're going to do this stuff. Let's see what else we got. Our scientist says, yeah, but Gottlieb's got the follow through. Yes. Our scientist also says, this is my hobby right now while I can't do my usual ones. Oh, well, I'm sorry to hear you can't do your usual ones. Is that a reason you want to disclose on chat? And if not, that's fine. This is a cheaper hobby than going to Spotlight for knitting yarn. Yeah, I mean, they get you with that yarn. It's fun times. Don't look at me, says Marcy Jinx. I walk my dog. I don't know nothing about it, me. I don't know nothing. I'm a dog. Was it dog catcher or dog? What was it? It was dog what? Dog catcher. Dog catcher. All right. So yeah, so that was kind of basically everything we got on the docket, bar one thing, which we'll talk about in a minute, which brings us to like the next big news that happened this week, which was a bunch of content creators got subpoenaed, which was really interesting because for weeks we've been told there's no coordinated campaign. This is all in Lively's head. She's desperate. This never happened. And then this article dropped announcing that 3 content creators were going to be subpoenaed by Lively because they were working or suspected to be working with Baldoni's team. And, you know, in response to this, we got, oh, this is fake information from Blake Lively's camp. They planted this article to smear these poor, innocent content creators. This is fake news, did not happen. There are no subpoenas, never going to happen. And I think most of you are like, we know that that's not how this played out, is it? Because the very next day they all kind of went, oh, so I've been subpoenaed. And I love this that Hanova Nolia, takes me a second to get had put up on thread saying, guys, we're not being subpoenaed. That's fake news 2 days later. All right, guys, I'm unboxing my subpoena. Let's go for it. Because they all then started to make YouTube and content about getting subpoenaed, which I said at the time, and I will still say, is a ballsy move. If you are getting subpoenaed and being dragged into this lawsuit, especially given that I think at least one of the creators didn't really have strong legal representation at the time and sort of like having to crowdfund a lawyer and stuff. I'm like, that seems ill-advised to be doing that without having your lawyer in the corner of your video, like making sure what you're saying is good. But hey, what do I know? Anova cracks me up to settlement. Oh man, I laughed so hard. I laughed so hard at this. I thought this was amazing. It was so good. So the unboxing. Yeah. I mean, like, and that's literally what they did. They showed their subpoenas and talked about it, and you're like, This is wild. The lack of concern or care you seem to be showing for this. Anyway, so like I say, this was all put out as like, well, this is Blake Lively leaking this. And I had said from the very beginning, as some of you in chat know, this is very much not Blake Lively. There is very clearly a party who is responsible for this, and it's not Blake Lively. So if you'll remember, this whole thing started when Blake Lively launched her CRD complaint and her article with the New York Times. And I pointed out how before that article ever dropped, before any of us knew about the CRD complaint, TMZ knew about it hours before because somebody had given them the CRD complaint along with Brian Friedman's statement to the press that he had given to the New York Times, meaning that it's very clear that Wayfarer tried to get ahead of the New York Times article and allegedly gave TMZ the CRD complaint along with Brian Friedman's statement, right? Like Lively didn't have Brian Friedman's statement, so she couldn't give it to them. It's unlikely that the New York Times is going to scoop their own story that they've been working on forever. And by the time the New York Times article came out, 12 other press outlets all cited TMZ as their source and talked about this along with Brian Friedman's statement. So it was a way for them to make sure they got Wayfarer's side of the article and their defense of all of this out before the New York Times article released. And like I say, this is back then. When they put out their amended complaint, again, TMZ, I believe, had it either at the same time as it hit the docket or slightly before. It may have been slightly after. But it's the reason why, as you can see, my copy of that I use has TMZ written all through it, right? It's watermarked all over it because TMZ had got a copy of the CRD complaint. I guess it must have been after it filed because it's got the filing stuff at the top here. So they must have done that. Then, of course, there was the, I think, is this, if I play this, I think radio resume. We'll have to get through the ad. I'll talk through while we go through the ad. When they gave the dancing scene and released the dancing scene, which had to have come from Baldoni's team because Lively did not have the raw footage, that was leaked to TMZ. So that was Baldoni's camp who released the dancing footage to TMZ and leaked it to them. What's this one? This was about, is it the website? Yeah, when they talked about releasing the website shortly afterwards. Brian Friedman gave a statement that he leaked gave a statement to TMZ talking about doing the website and all the rest of the stuff. He's been on TMZ a number of times, right? He appeared on after the case was dismissed, talking about how Blake Lively's on a false victory tour and all of this stuff. I think he's made like 3 or 4 appearances on TMZ now. So they're very clearly leaking and talking their information to them. I forgot about in Baldoni's own in his own timeline. I forgot about that. Jennifer Abel talks about that. I think it's August 7th. Yeah, it's right here. Not on that one. Is it right before it? Or did we lose the text message? Ooh. Just gonna say, would rather be at the front. I just don't know my job. Do you think we need it? Did they change the text message here? Do you think we need it from what you're saying? Oh no, this is afterwards. Blah, blah, blah. There it is. From my friend at TMZ. Right? Ooh. From my friend at TMZ. So Melissa Nathan was getting tips from TMZ. So very tied in at TMZ in Baldoni's camp. Yeah, so this is the whole interview with Friedman talking about she's doing a false victory lab that he did. And then the whole Taylor Swift thing. When the subpoena came out and it was on the docket for Venable, they also talked about another party had gotten an individual subpoena and it was suspected that obviously it was Taylor Swift. Well, that was confirmed by TMZ because a source with direct knowledge tells TMZ that Baldoni's attorney, Brian Friedman, has now subpoenaed Taylor. So again, Team Baldoni had leaked to TMZ that Taylor Swift was being subpoenaed. So it seemed very clear to me that this was Baldoni's team leaking this to TMZ. And the question then becomes, well, how did they know? How did they know that they were getting subpoenaed if Lively's issuing them? And the answer is, if you remember from the Taylor Swift Venable subpoena, look, I think it was Lively included the email in the Venable motion to quash. And you can see that Liner Friedman, Tattleman, and Cooley said, hey, please see attached notice of subpoena, and sent it to Lively's legal team that they were going to subpoena Venable. And they respond here and says, hang on, we're in receipt of the subpoena to Venable that you noticed. We're evaluating whether we want to object. So they had sent that subpoena ahead to Lively's team. We knew about it. So here's the subpoena. The reason for this, and a thank you to MJ Morley. It feels like I don't do a stream without thanking MJ Morley. More with MJ over on Threads, who had put together a TikTok video talking about this and saying, well, that's because it's part of the rules, the federal rules of civil procedure of subpoenas, that when you go issue a subpoena, if it's going to command the production of documents, electronically stored information, or tangible things of the inspection of premises, before it is served on the person to whom it's directed, before you send it to Perez Hilton, before you send it to whoever else, a notice and copy of the subpoena must be served on each party. So Wayfarer got a copy of those subpoenas before they went out to the other parties. So that is how TMZ got it, was because Wayfarer had it and then leaked it to TMZ. Now I had said, well, why are they doing this? Why, if they're going to be subpoenaed anyway, why go ahead? And I had said, well, I feel like this is them giving them a heads up, saying, hey, this subpoena is incoming. It doesn't surprise me that this was also on July 1st, which was also the date for supposedly substantial completion of production of documents, which we'll get into. That doesn't appear to have finished or have happened. So I had suspected that Wayfarer had possibly handed over something in production that they knew would bring about these subpoenas. But it appears probably that production happened a little earlier, and that was why Lively's team had subpoenaed them. But it also means that they had subpoenaed them based on something. Lively's team are not going to issue subpoenas based off like they want to go fishing. There's a reasonable reason for issuing those subpoenas. So like I say, it feels very obvious that Wayfarer decided to leak this to TMZ, which has been their preferred media outlet for all of this leaking that has gone so far, to give them a heads up. Now, like I said, for some reason they decided to put this all over their social media content. Atticus Silva says, sadder still, those content creators staring into empty mailboxes, desperately awaiting validation. Yeah, I'll get to that in a second. Sotomayor says, TMZ is definitely not affiliated with Blake. Anything that comes out through them is from Baldoni's camp. Yes, I do believe Gottlieb had done like one interview with them, but for the most part, Blake's team do not really use TMZ as a source or place to leak information. It has been pretty much all one-way traffic from Wayfarer in that respect. Scientist said, TMZ already publicly offered to testify about the PR happenings last August to Friedman's face. Yes, that was a beautiful interview where Friedman was like, oh, we know that Lively's been like, trying to plant stuff with you. And then they turned both around and was like, well, so have you. And I'm like, so like, yeah, they were quite happy to throw him under the bus. Atticus also says, unboxing subpoenas is kind of crazy. Yeah, it's wild to me. A scientist, the creator had a lawyer to release a statement when the subpoena wasn't real. Yes, they did, saying that they were waiting for it. Karen McKenzie says, a little behind in catching up, but I thought Street's argument was good, but Blake Lively's comeback was solid. Should be interesting to see how Lyman rules. Yeah, I think a couple of us have talked about this week of like, I get swayed one way or the other, right? This is good with legal reasoning, especially when you are not a lawyer. Like, sure, sounds smart to me. Like, and I've felt that way a lot with Wallace's arguments. has been like, oh yeah, that sounds really smart. And then Lively's comes along and I'm like, oh no, that sounds absolutely terrible. Lively's right. And then Wallace comes along and says, no, 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 this is terrible. And for the most part, I felt a lot of that back and forth and whiplash with these movements. And this one in particular, I do feel like, oh, I also felt convinced like the stay was going to happen. I was like, yeah, I could see a reasonable argument for Wallace's stay, and that didn't happen. So I think I was wrong about that one, because I think I did say he was going to get a stay of discovery, and then it turned out that Lyman said, nah, you're good, keep going. Obi-Wan Kenobi says, I think their audience all missed the point of the subpoena. It wasn't what was said, it was where it was where they got their info. Yes, and we'll get into that in a second. Junk Farm says, the other part of this is Sloan is accused of saying SA. Lively could have gone on 60 Minutes with GMA and flat out accused him. They didn't need to leak it, they could have just said it. Yes, true that. All right. Mary Marcy Jinx based 11. Yes, it was probably one of those rare moments of like, oh, good job, good job. So I brought this up because Candace showed her subpoena on screen, and I took examples of the other subpoenas because this was before it was confirmed. I was like, I don't know if this is legit. And one of the things I noticed, right, we just talked about the federal rules of civil procedure. One of the things I noticed is that in the other subpoenas, this is the one that was issued to Katie Case, the one that was issued to Tara Hanks, both from Lively. First point is, in addition to specific instructions below, these requests incorporate by reference the instructions set forth in Rule 45 of the Federal Rules of Civil Procedure. Candace's, however, is missing that. Apart from that, it is an identical copy of Katie Case's subpoena. Even the dates are the same, period of, oh no, not Katie Case, is it? I think I got these the wrong way around. I might have got these the wrong way around. I think Katie's might be the other way around, because I thought Katie's was May 1st through the present. But either way, it is a direct copy of this one. We'll figure out later whether it was to Katie Case's or Tara Hanks and I got the names wrong. But you can see here, May 1st, 2024 through to the present. Same for Candace's here. Otherwise, it's virtually identical, but it misses that first point. And I was like, that seems really strange because all the others have it. I don't know if it's a difference in how it's being served or the courts that are being used, but why does it not have that same preliminary instruction about Rule 45 of the Federal Courts of Civil Procedure? Anybody knows, if you were watching this and you want to drop that in the comments or in chat, please let me know, because that is a bit of a mystery to me. But otherwise, it's identical. So yeah, so Candace threw hers up and has basically said she'll comply with it, but only from May 1st through to December 20th when the thing went live, because she's not going to show all of her sources and how she knows all this stuff, and that she's not going to give up her source that told her that Taylor Swift's dad had given all of that information to Wayfarer. And I thought that was really interesting because, as we know and has been confirmed by Wayfarer themselves, Taylor Swift's dad didn't hand over anything. Nobody's handed over anything to Wayfarer. So somebody is clearly lying about that. And you would think that Wayfarer would probably be interested in knowing who is lying and providing this source to Candace saying these things. But it's also interesting to me because Candace also said, you know, I didn't even know any of these people until this lawsuit happened. So why would you have any relevant or producible discovery before you started making content? So saying that you're going to comply with the subpoena before you made content, but also you didn't know who these people were before you made content, like you're quite clearly showing that like all of the relevant information is going to be afterwards, and that's the stuff you need to hand over. But they're fighting it. They're fighting it. Now it's interesting because a number of these creators have actually, the Baldoni creators, have been bragging about having contact. Actually, let's go to the other one before we get to that. One of the other creators, for an example, naturally we will get to what I was going to talk about first. We'll go the other way first. Had been talking about, like we have heard for months, this smear campaign thing is a red herring. It's a desperate act. Nobody can believe that people just hate Blake Lively, blah, 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 blah. And they have been saying that there's been no contact all this time, right? And yet, at the same time, Baldoni creators have been openly bragging about their contact with Team Baldoni. You can see here, this is Perez over on Reddit talking about James Vituska. Thank you to Sarah Siegel for this. She made a video on it, and that's where I found this from. So definitely, if you don't already, go follow Sarah. I think Sarah has been consistently one of the most even, neutral, and fair commentators on this. Just in her ability to have a balanced conversation and respond to people who I've always felt are obviously trolling and operating in bad faith, but Sarah will engage with them in good faith and have a good discussion with them. And yeah, I don't think I have the blood pressure for that. So appreciate you for doing that work. But anyway, they had made a video talking about this, of that, you know, in terms of the rumor from, I think like last week or the week before, about James Vituska getting new lawyers and possibly being let go by the Daily Mail, which has not been confirmed. Here is Perez saying, no, I've got this confirmed because I've talked to Team Baldoni. Somebody on Baldoni has talked to me, and this was like a week ago. And yet we've seen nothing on the docket, no news about this. Now, I'm not saying it's true or not, but I would think that there would be some more information on this if it was true. But also, this is Perez literally bragging about, like, oh yeah, I'm in direct contact with Team Baldoni. I have sources in there who are directly feeding me information, which is interesting. They're not the only creator. Other Baldoni creators have openly bragged about their contact with either members of, you know, Team Baldoni generally, or friends or family of Wayfarer or Baldoni and his circle. And it's interesting to me for them to like openly brag about this while also trying to say, hey, there was no contact. So it's not surprising that then they got subpoenaed, right? And like I say, we've been told for months that there's been no contact. Now, of course, there is contact, and what we're hearing instead is that they are journalists. Of course, these are our sources. These are our sources. We're journalists, and we have to protect our sources. But if you are a journalist, there are standards, codes of ethics, and conduct that you adhere to as a journalist. There are not for content creators. And so it seems very much like they're trying to play both sides of having the freedom to not be held to a code of conduct, code of ethics, while also trying to claim the privileges and shields of being journalists. But that's not really how it works, and I don't think that's going to work for them. But anyway, we'll get into a little bit more. Another content creator had talked about that they're not going to hand over anything. And then, in fact, they're going to double down on what they're doing in making a like smear documentary against Lively. And I think that's also a bold move, where there is an alleged smear campaign, where there was direct contact from Baldoni's team to push defamatory and hostile content towards Blake Lively. And your response to that is, I'm not part of any conspiracy to create that kind of content. So what I'm going to do is I'm going to gather a bunch of other creators who also are not involved in this conspiracy to make defamatory content against Blake Lively. And we're all going to get together to make defamatory content about Blake Lively. That's how you get subpoenaed, right? And you are making, in this case, a documentary, a movie. You are not going to be protected by journalistic standards, right? Or news reporting. You are very clearly making your own content and entertainment. So as you go about that process, expect more subpoenas and expect that you will have to hand over your materials and conversations around it. It does not seem like any of these people are really consulting legal advice around this. And I would definitely recommend that they do. Yeah. I'm not going to mention any of the names. I think this does somewhere, yeah, it does say they're in there, but I'm not going to mention any names. So as we go through this in chat, if I read out comments, I'm going to avoid saying names. One of the creators is so desperate for attention, they need to be held credible. They really stuck their foot in the mouth in this one. Yeah, I don't know why you would admit it and then not. I would bet Vituska was issued a new email, says Mossy Jinx. Yes, that's the suspicion. But we'll see. Other creators having subpoena envy. Oh, absolutely. I think they're very upset that they aren't. And I think this is like, I've talked about this, like, I've talked about this a number of times. Like, people have said to me, like, oh, have you not, like, oh, that's a really good find, or you found like this great tip. Have you not shared this? And I've said no. Firstly, because I'm very aware that all the parties involved are actively like watching our content and seeing what we're doing. Actually, to that point, I can probably bring up something today that I have not shared publicly, but I will share with just me and you, chat. We'll just share it together. Nobody else will know. But I'm very aware that they are seeing some of our content, seeing what we're doing, and watching our stuff, right? So I don't feel the need to send it anyway. And if you do send it to them, this is how you get subpoenaed, right? If you start being involved, and I think a number of Baldoni creators were like, you know, the running joke of like, send this to Friedman, send it to Friedman. Yeah, that's how you end up getting subpoenaed, right? Like, it's because you are getting yourself involved. And it's so weird to me that these creators were bragging about emailing tips to Wayfarer, to getting in contact with them, to getting their sources from Team Baldoni, of being like in contact, directly messaging, involving themselves in this lawsuit, and sort of like baiting and like bragging about like, oh, I hope they serve me, I hope I get a subpoena. And now that they've got a subpoena, they're running around and claiming like, I'm being silenced. Oh, they're trying to, you know, shut down small creators and do all the like, no, you involved yourself and you did not seek legal counsel before this. I have said consistently, like, I'm not going to talk to anybody involved in this case. I'm not going to reach out to the parties on their side because I don't want to be involved. I don't have any fear of getting a subpoena. If somebody wants all of, you know, the information and contact that I've had with either Blake's team or Baldoni's team, like, you are welcome to. It will be very easy and not a burden for me to produce at all, because it's zero. And like, I would like to keep it that way. So I don't want to get subpoenaed, but if I get subpoenaed, it's going to be not a problem. But it's just, it speaks to this dangerous need for attention that these creators have, of they want to be recognized. So like I say, I'm saying we're already know to be watched. Facebook recommended me a new contact. I don't use Facebook. I haven't used Facebook in a couple of weeks. But yeah, apparently I'm getting recommended Baldoni's legal team over on Facebook. So I don't know if they're looking, or if it's just a random quirk of the algorithm, but interesting either way. So yeah, I don't want to get involved. I don't want to be proposed up at all. But I talked about this, like, you know, this whole complaint that they're crushing freedom of speech and everything. And I said, like, it's not freedom of the press they want. It's freedom to harm women without consequences. And that's really what's going on here. They want the ability to make this defamatory content, to consistently for months be able to profit off this continual smear machine, and then act all shocked Pikachu when they then talk about, oh, I'm getting all this information from Team Baldoni. And the thing I would say to you is this: even if we accept that what they say is true, right, that they're just getting sources, they're just, you know, the journalists. If you think about, let's think about, there is a smear campaign, right? What Lively's alleging, let's say it was to happen, hypothetically. We all know, apparently, according to Team Baldoni, never happened, but theoretically, if you had a bunch of creators who were making this content and who were getting instructions or getting talking points or being fed information by Team Baldoni, how would that look any different than the current content creators churning out all of this misogynistic content, bragging about using Team Baldoni as a source? I don't see a discernible difference between the two. That difference is such a fine line between, like, oh, I'm a journalist checking sources and I'm a content creator who's being fed information to make defamatory content with and being like encouraged, and I being, I don't know how to generously say this, somebody who is very much taking Wayfarer at the word. Let's just say it that way. If they feed you information and you just blanket report it, you're not really being a journalist. There's not much difference between them feeding a creator to make smearing content from them and feeding you, journalist, information from your source that you then make content about. There is no discernible difference. So you shouldn't be surprised that this happened. So anyway, Joke Farm says, I don't know how to fix it, but YouTube should be censoring this slop. Agreed. And I think there needs to be some way to navigate this without infringing on the freedom of speech principles of being able to offer opinion, while at the same time not necessarily being used to conduct this sort of campaign, if it exists. Again, don't know. And I think it will probably turn out that these creators probably weren't given a lot of information and stuff to do. But they are fighting it. They're probably not going to hand over a lot of information. And I want to talk about how that's actually probably going to be good. Good for Lively. I forgot what this is. Okay. Going ahead of ourselves, so we'll wait here. It's actually going to be good. So, the thing is, they didn't issue these subpoenas out of nowhere. There was obviously some basis or information or relevance to doing it. And so if the creators want to lock down and say, hey, look, I'm not going to give this information, we're going to fight it all the way. The good news is that, this can then be used for summary judgments, where if we're not able to get the evidence to show that the way that this contact was initiated, the way that they were talking to these creators was innocuous and innocent, and more of this journalistic, like I'm coming to you for background, or I'm coming to you for clarification on issues, rather than what it seems to be, which is Wayfarer Baldoni like feeding talking points like Vituska's been fired, right? Then if they want to lock that down and not provide that clarity, then eventually what can happen is they can be used at trial to kind of infer the reason they're withholding evidence is for a bad reason. That while we don't have the evidence that they were colluding with these content creators, their refusal to hand over information can be used to say, hey, you infer that. Because they don't want to hand over the information to clear their name almost. We can assume it's because it's bad and it implicates them. And the jury can be instructed to act as though that information is true. So that's really damaging for Baldoni's case if these creators don't want to hand over that information, which it seems like they don't, because they want to protect their sources and they want to protect other conversations they have, and totally within their rights, I understand wanting to do that. But I think ultimately that could actually hurt Baldoni's case. And I think that's an irony of, for months now, these people have been generating content wanting to support Baldoni and encourage and help his case, and they could actually be a major stumbling block when it comes to trial of providing any evidence that exonerates him, and instead actually kind of implicating him in the smear campaign. But we'll see. Not a liar. Junk Bomb says maybe if she had to pay a huge slap penalty if she lost or something, maybe. But treble damages if she wins, 100%. Like, it's so bad. Subtle says they're incriminating themselves by not doing it. It's obvious they're hiding something. And it's not. Like, I mean, again, like, it might not be. It doesn't necessarily, like, not wanting to comply with the subpoena doesn't necessarily mean you're hiding something. But not providing the evidence means it can't be used in trial. And that's going to be harmful, because without the presence of that evidence, again, there can be summary judgments, and the jury can be instructed to infer the absence of evidence is for a bad reason. So, like, I don't know, like, that's rough if you are showing up to support Baldoni and now, like, you could actually really damage his case by your refusal to participate in it. So we will see. So it did talk about, like, well, let's go into the other piece of this. So talking about that, that news for Baldoni gets worse as we talk about discovery and moving into the case, because the other thing that happened, and I believe this happened last night, late last night, Lively filed a motion to amend the case management plan. Now, as it stands, substantial completion of document discovery, got to be careful here, was supposed to be complete on July 1st. Discovery itself is supposed to be complete August 14th, with all of the depositions also to be completed by August 14th. I think, party discoveries by August 14th. And then we're just going to bring up the case management plan, because I clearly don't know what I'm talking about. Because I remember there's also, like, expert discovery in August, right? So it was fairly early on the case management plan. This is it. All right, let's bring this up. Let's talk about it as if I actually know what I'm talking about. Discovery will be complete by October. There we go. All right, so yeah, like I said, where was the July 1st? I thought it was further up. But yeah, substantial completion of document discovery was July. It's in here. Oh, there we go. Substantial completion of document discovery was July. Fact discovery completed by August the 14th. Depositions by August 14th. Expert discovery by October 15th. And all discovery by October 15th. Lively has asked for a change to that. And yes, Mossy Jinx says they're going to run it concurrently now. Yes, that was what we're looking for. They're trying not to push the dates out, but trying to run some of those dates more concurrently so they can get some more time to complete fact discovery, essentially. So basically what Lively's saying is that on June 25th, counsel for Lively tried to propose to counsel for Wayfarer parties Wallace and Jones works to extend the close of fact discovery by a month and complete document production by July 15th. So push that back by 2 weeks and close fact discovery in September rather than August, and entered into a shared briefing schedule in connection with discovery. On June 27th, Wallace parties and Jones Works agreed to that proposal, leaving Wayfarer parties as the only parties who did not agree. And then on June 26th, counsel for the Wayfarer parties indicated that they would produce 100 terabytes of film footage, which Hutchin says roughly amounts to 50,000 hours of viewing time. We'll get into that into a little bit later, but I do think those numbers are a little high. But 50,000 hours as a ballpark is like 5 years of film footage that Wayfarer just dumped on them, having asked for that film footage for months. Wayfarer on the last day was like, here you go, here's 5 years of footage. But like I say, I think that number's high. We'll talk about that in a little bit. On June 27th, the parties, except for counsel for Jones parties, convened telephonically, to discuss the deposition scheduling, wherein counsel for Wayfarer parties claimed to have limited dates of availability for their clients' depositions, without clearly explaining why their clients would be unavailable. On June 30th, the Wayfarer parties confirmed in writing they could only offer 1 or 2 specific dates for each of their individual clients before August the 14th. All of them are very busy people, apparently. On June 30th, the Wayfarer parties began to produce the film footage. And then on the evening of the July 1st, the Lively, Jones, and Wayfarer parties made productions in connection with the case plan's deadline for substantial completion. The Wayfarer parties' productions, however, produced just before midnight, appeared deficient. For example, in Lively versus Wayfarer Studios, Abel produced 200 documents, 229. Nathan and Tag each produced the exact same 81 documents. And in the Jones versus Abel case, Abel produced 119 documents, which seems really light in the case in which she is a main party. Baldoni produced 98 and Nathan produced 144. More importantly, Abel, Nathan, and Tag failed to produce reams of responsive communications that they are known to possess, including many texts produced in response to the Van Zandt subpoena. This is crazy to me. So what they're saying here is that we have those text messages, right? We got them from Jones, from Abel's phone. We've asked for them from Nathan and Abel and Tag. They haven't handed those over. We know that there are large numbers of the text messages we already have that are missing. To understand, this is bad, right? Because it shows, firstly, bad faith. You're not producing the correct evidence. You're not producing all of the evidence, and you are attempting to hide, destroy, or fail to produce evidence. This is evidence spoliation. This is a big deal, and again, can result in the judge stepping in and issuing a summary judgment of, hey, given that they have tried to destroy, hide, or in other ways try to not give you evidence, we're going to act as if and conclude the facts based off this. It's so wild to me that Blake Lively had handed over all of the Van Zandt documents. So first off, you have this situation where Wayfarer are refusing to hand over text messages and saying to Blake Lively, well, you need to hand over all the ones you already have. We're not going to hand over you our text messages until you show us which ones you have them, so we know which ones to give you. And even having that information, because as we know, Blake Lively has handed over those Van Zandt documents to them and did so, I think we talked about like a few weeks ago, like 6 weeks ago. Now, at the deadline of July 1st, they hand over messages from Abel, Nathan, and Tag and just forget to hand over a bunch of messages that Lively already has, showing that they are intentionally operating bad faith and not handing over evidence. This is a huge deal. Now, I have seen a couple of people online say, whoa, that's because Abel doesn't have her phone, remember, right? Jones has her phone, so she wasn't able to access her accounts, wasn't able to access any of her text messages. There's a huge problem with that argument. So the first problem with that is Abel's amended complaint in Jones versus Abel. So Abel provided her answers to Jones and then provided her own counter allegations, right? And a lot of her screenshot emails are her text messages are these screenshots, right? Where maybe she doesn't have access directly to the device. Maybe somebody took that picture for her, something along those lines or whatever, right? But further down, we very clearly have this conversation between Jennifer Abel and a Jones Works employee. You can see here, Jennifer Abel is very much in the blue on the right, showing that it's from her and this is her phone, right? That we're seeing the screenshot of, that she sent this message. And this was after she left. So clearly she has access to some text messages. Okay, fine. All right, so she only has access to the text messages after she left then, right? So she can't produce all the ones from before that Lively has. There's a slight problem with that one. So Baldoni's timeline of events, which continues to be the most epic own goal that Wayfarer ever kind of put together, also includes a number of text messages from Abel from before she had her phone taken with her, showing that she had access to the devices. So first one is right here, that is from from July 10th. Conversation between Jennifer Abel and Stephanie Jones, where Jennifer Abel, again on the left, on the right, showing it's her text message, her device, her phone. She clearly has access to this either screenshot or to the actual text messages themselves. From back then. This is not the only one that is included in here. Page 102, we also have this exchange here between Jennifer Abel and Stephanie Jones, which is very much her text messages between the two of them. This is from July 24th, again before the phone gets seized. And then also on page 106, we have this whole back and forth with Jennifer Abel on the right, showing it's from her device, her phone, with Stephanie Jones, showing she had access to these text messages. So she had access to her text messages enough to be able to provide them to Wayfarer to put into the complaint, but not to hand over to Blake Lively as part of discovery. That's bad. That's really bad. So I guess this is why Blake Lively talk about forensic retrieve, but yeah. Subpoenas says there's no way they can be forced to present the evidence. I don't believe so in civil cases. There could be judgments against them. I believe there could be sanctions, fees and stuff, right? But it's civil court, right? You might go for contempt of court. I think you can go to maybe jail. Like, I don't know. I don't do law, right? I do code. I don't believe so, right? There's not a way to like physically like snatch relevant devices, have the FBI come in kind of thing and like seize computers or anything like that. That's not going to happen in this case. What will happen instead is, like I said, it will just be a summary judgment of if you're not able to provide this information, right? And Blake Lively has these text messages. Not only will you not be able to use those text messages to defend yourself, but the jury will be instructed that we can just go ahead and assume that Abel was part of the smear campaign, was directing these things, and that the information that Blake Lively has and the way she presents it is the truth. And that is a huge problem for Wayfarer, right? Because you don't want to do this. You don't want to go into a case where the judge is basically instructing the jury with this list of things of like, don't believe them when they say this, assume this is bad, they did this. You don't want to do this. So you would make very careful that you are producing all of the evidence, that you are not engaging in these kinds of activities because they are so incredibly damaging for you and your case. And yet Wayfarer do not seem to care. This is another indication that they don't really care about this going to court. This is about maximizing the amount of hurt before this gets to trial, because they are very clear that if this goes to trial, they will lose. And so they are trying to, as best they can, create as much pain and damage before they get to trial and ruin the trial itself. But it's going to be a problem for them. It's not going to work out well. So you know, it's frustrating that they're not handing over evidence, but at the same time, there are remedies for this, and I don't know why they think this is going to work out for them. She does go on to say that, though, that Wayfarer, it ends with us, Heath and Baldoni have produced 170,000 pages of documents, which is a lot for them to go through. On July 2nd, the Wayfarer parties confirmed substantial completion and that not all, for Jones' work, any film footage had been delivered. So they missed a ton of film footage and didn't deliver any of it to Jones' works. In addition, counsel for the Wayfarer parties neglected to send relevant productions to Jones parties in a timely fashion, including the film footage, none of which the Jones parties have received. And Jones parties have not been involved in discussions regarding coordination, schedule of depositions. As a result, the Jones parties are willing to confer on mutually acceptable schedule and deposition protocol. They have not yet agreed to or been involved in any deposition scheduling or protocol. So, yeah. It seems like there's a mess going on over on the Jones work side of things. So on July 3rd, in light of the volume of party discovery, potential deficiencies in the satisfaction of substantial completion deadline, and the fact that not all parties have received productions by the deadline, Lively has proposed the further modifications. So we're going to extend fact discovery from August the 14th to September the 30th to run concurrently with the expert discovery schedule. Completion of the party document productions for RFPs by July 25th. And then a shared briefing schedule on the parties' motions to compel in connection with the document party discovery opening on August 1st and responses on August 8th. So it sounds like there's still a bunch of stuff outstanding that has not been complied with that they will all have to negotiate and work together with through that first week of August. It's a lot. It's a lot. She goes on to say that we have good cause for extending this stuff. Again, our favorite case, Furry Puppet Studio versus Fallout Boy, is brought back up again. Classic. We love good Furry Puppet Studio. Despite the party's progress in fact discovery, the case plan as initially ordered is no longer workable. She again talks about the number of documents that have been produced. Sarowitz appears to have produced 3 pages. Nathan and Tag collectively produced less than 300 pages, while by contrast, Lively's produced 5,000 documents and over 21,000 pages as a single individual. The Jones parties have produced 12,000 documents and 37,000 pages. So very clearly, they are overproducing on the Lively Jones side of things. Aside from substantial completion, the aforementioned 170,000 pages and footage, which will take days to access and process into a reviewable format and a number of weeks to review, also stands a substantial barrier to conducting depositions. Lively had repeatedly stated that she wanted the film footage before doing her deposition, so it's no shock that as they come to the wire, Wayfarer just basically dumped a ton of film footage that is not in an easy documented or timelined view to make that difficult, and then to make it look like Lively is being unreasonable by pushing out her deposition because she wants time to review that film footage first. And again, she's entitled to, right? Like, you don't get to just surprise it. I think a number of people on the Baldoni side were like, well, you know, she wants to check the film footage so that her testimony and deposition aligns with the film footage. Yeah, probably. Like, she wants to remind herself and refresh her memory and make sure that what she states is the truth. And like, wouldn't you want that though, right? Like, if her recollection is incorrect and this sexual harassment never actually occurred, and she reviews the film footage and sees that, and her deposition is, oh yes, I was never sexually harassed, like, that would be a win for Wayfarer. I don't know why you wouldn't want that to occur. So it's very strange to me that they're like, she wants to review the film footage. Yeah, she's allowed to. She's allowed to review the evidence beforehand. Like, that's part of it, I believe, of like going into those depositions was to have all of that material. Yeah, strange to me. Miley says, yeah, the Wayfarer lawsuit was the definition of a retaliatory lawsuit. I actually hope it can be included to support the argument of retaliatory smear campaign. Yeah, I think that's what we're going to see with the Liner stuff. If Liner's motion to quash isn't granted and Lively does get access to that information with Liner, without saying too much, because I don't want to reveal stuff that isn't out there right now, there I think is a second smear campaign. I know, right? Lively hasn't proved the first campaign, and here's Expatriarch inventing a second smear campaign. I think there's 2. right? There's very clearly the one that Jed Wallace was involved in allegedly involved in through August to whenever that ended. And I think there was a large PR campaign around Baldoni's litigation. And I think the Liner motion, if it's granted, will start to expose large pieces of the fact that TAG continue to be involved with Wayfarer, continue to be heavily trying to massage and PR this, and was involved directly with Liner Friedman in order to do that. Now, again, all speculation. I'm not saying any of that is fact. This is all theory crafting, right? I'm not alleging anything. I'm not saying they did. I'm saying that, in the realm of possibility, that's where I think things may be going from. I'm not alleging that anybody actually did that, or that's what we'll see. We'll see whether that theory crafting and speculation of mine is truthful and correct, or whether it turns out I'm completely wrong, right? So I will hold my hands up and say that, but that's where I am leading. This is where I think this is headed. The depositions too are a crucial element of the party discovery schedule. Lively had talked about this, wanting like some of this information about it. The plan is that there will be 40 depositions. We'll get to that in a second. Require several sequential weeks of multiple depositions each business day across California, New York, Texas, and Illinois. Exacerbating the issue, the counsel for Wayfarer parties have provided negligible availability for their clients, apparently intending to choose their preferred order of deponents. For example, asserting that Miss Nathan and Miss Abel are unavailable all of July, and Mr. Baldoni is only available for 2 days and only after Mr. Heath. We'll get to that in a second. So basically goes on to say, look, we need to be able to change this and extend this out. I think this is a reasonable request. I think it will be granted. I think also it is going to make Lyman upset and not very happy that this is having to happen. It shouldn't overall affect the timeline of the case, and that's what they're saying, is that they're just going to run it concurrently with expert discovery. So it shouldn't push out the trial date, shouldn't push out anything else. So everything else should still be fine, but they need extra time, at least in this initial discovery phase. We'll see, right? So depositions. Mr. Baldoni is available next year. He's available once the trial is done. That's the only time you can do that. Spoilage can be construed spoilage. Is it spoilage or is it spoliage? Because when I've seen it spelled, it's the other way. But anyway, spoliage can be construed against the spoiler. Yes. And Nabi Monkanovi says, if you lie about one thing, yeah, I mean, that's the other thing, right? Like it starts to really harm their credibility, that as you get these summary judgments and you're shown to not be telling the truth about these one or two things, it damages then your credibility going forward for the rest of your case. Again, like, I don't know why you would intentionally go about your trial and litigation strategy in this way, unless you were not planning to go to trial, right? You want to avoid trial at all costs and just make it so costly and miserable and keep dragging it out and make it like just bleed money. But with the fact that fees are probably going to be awarded, like you're only going to end up paying for it yourself anyway in the end run. Like you're putting a huge bet on dragging this out for as long as possible, that it never goes to trial and that you don't lose when it does. But if you can't use any of your evidence because you didn't hand it over, your chances of winning that trial are very slim. I don't know. Is he too busy being spotted at Disney? Spoilers? Yes, we're gonna get that subtle murder. So we're talking about they asked for the deposition date. It looks like Wayfarer did produce some documents, right? They were doing some rolling production here as of May 23rd. But I think we've seen motions from Lively since then saying that they didn't provide anything. So, like, did they provide something or did they not? They also provided the SFTP link for this as well, which I don't know if that's smart, putting the actual link for this in here, because I'm fairly sure that's just username password. So let's hope that they are got some brute force protection on that, because now that address is out on the internet, there will be people wanting to get that information. So don't think that should probably have been redacted. Anyway, so Kristen basically or I should say Bender, call her Bender because I tend to use everybody's last name, goes on to propose basically there's going to be, instead of the normal 10 depositions, there's going to be 20 depositions for each side. And it looks like this was based on originally, before the cases get dismissed, the fact that there would be a combined side of Lively, Reynolds, Vision, and Sloan, right? And the four parties would have that 20 depositions collectively, with then Wayfarer, Baldoni, Heath, Sarowitz, Nathan Tagg being joined with Wallace and Street Relations to have 20 on their side. Seems fair. Given that there's like what, 9-10 defendants on a Wayfarer side, all of those depositions would just be the named parties. So it seems fair to add some extras. So they seem to agree. On Sloan's side, Wayfarer kind of say we'll get back to you. They agreed to the total number of depositions. Let me work in this weird one. We suggest that the parties work towards an agreement as to how to count depositions of third parties that both sides wish to take. For example, if both sides wish to depose the same third party, the parties could split the time equally and count it as only 1/2 of the 20. So let's say both sides want to depose Katie Case. I think this would be one example. They could, and they could both talk to her, but instead of the 7 hours, they would both get 3.5 hours, and it would only count as a half deposition. I don't know how common that type of thing is, but that seems a little strange. I mean, it sort of makes sense if you have a lot of these third parties that you don't necessarily need a full 7 hours with, to be able to kind of do a half session with and then split it. But I don't know if this is like super common or if this is something that is out of pocket. Marcy Jinx says witnesses on set. Yeah, okay, that's another good example. The assistants to Baldoni and Heath might take a lot of time, but you know, if like you want to pull in somebody who was around for the sexy comment, I guess, or the filming of the intimate scene between Isabella Ferrer and I've forgotten the young Atlas's actor name, and I apologize. But if you want to take the, you know, depositions of people who are around for that scene and heard, you know, allegedly Baldoni talking about that was hot, that might be another one. But I would have thought witnesses you wouldn't necessarily depose, you'll just bring into trial. I think depositions are usually for people a little more involved, but I mean, I say usually as if like I have any familiarity of law or cases. That seems weird though if you both have questions. Yeah, I mean, like, I don't know, like, would that be like you get 3.5 hours and then you come out and then somebody else goes in? Because that would, you don't necessarily want opposing counsel in the room at the same time you're deposing them to hear what questions and lines of questioning you're asking them. So you definitely want, like, you know, cone of silence, and then, I don't know. Like I said, I don't know how normal or strange that is. Marcy Jinx says, every deposition I've seen has questions from both sides, not a lawyer, but it should just be normal depo stuff. Oh, okay. I don't know. Never been involved in a deposition. I hope I never am. So, yeah, interesting stuff. So then let's look next is the proposal. Where, you know, Friedman's law firm comes back and says that Baldoni is available only for July 30th or 31st. Jamie Heath is only available for the July 28th or 29th. They come back and talk about the changes that we talked about, going from August to September, completion of the RFPs by July 15th, and then opening the schedule for briefing on the motions to compel by July 29th, asking them to agree for it. Jed Wallace's argument, Jed Wallace's counsel says, yes, we agree. She goes back to find it again. You know, and will they also agree to indicate whether they agree to designate Tagg's second supplemental responses to Lively's interrogatories dated June 25th as non-confidential? They come back and say, the Wayfarer side, that they want to discuss that and do a meet and confer on that. But they also want to talk about, we're preparing to depose Blake Lively on July 17th. So we now have a new date for Blake Lively's deposition, which is July 17th. It apparently did not happen on June 23rd, as we suspected, but there was never any announcement or fanfare around it being rescheduled. So I don't know, at the time that Brian Friedman was announcing that it was going to be June 23rd, whether they knew that this was going to be rescheduled, because this doesn't look like it got rescheduled until recently. July 1st here is when they're talking about it, so I don't know when exactly. With respect to your objection to TAG's confidentiality designation, we're available to meet and confer. During the call, we'd also like to discuss the timing for providing the other party or side with documents received from non-parties pursuant to subpoenas. We are concerned and have been made aware that there's been a delay between when your firm has received responsive documents from a non-party and when they've been shared with us. So they seem to be referring to something in particular, and apparently Kristen Bender knows exactly to what they're referring. She goes on to say, the Wayfarer parties have received all third-party productions that Lively has received, and on a timely basis. Please identify in advance of our meeting which delays in the provision of third-party productions you purport to be referencing. If you're referencing Miss Slate's production, I presume you're aware that the production link was initially provided promptly on June 12th and then was re-provided with full production accounting for any technical errors within one business day of Wayfarer parties bringing it to our attention for the first time on June 20th. So that means that since June 12th and fully since June 20th, they've had Jenny Slate's responses and production discovery materials, and it seems Wayfarer feel like they don't have all of it. They're going to say, thanks, Kristen, I've circulated a link. With respect to Slate's production, my understanding is the link you provided us on June 12th only included Slate's written responses and objections, not the responsive documents she provided your office. Please let me know if that's incorrect. And she'd said here, yes, we provided you with the new link on June 20th. And so you get the hilarious legal version of, please see my explanation immediately below. As per my last email, which addresses this. We will be happy to discuss further tomorrow as needed. And then she goes on to revise that schedule based on, I guess, that conversation. RFPs by July 25th, not the 15th. And then the motion to compel briefing schedule on between the 1st and the 8th. Please respond. And it seems like Quinn Emanuel for Jones Work say that they agree, but there's no response from either Wayfarer or Jed Wallace. Oh, I forgot. There's this also one other last piece. So we talked last week about the TAG employees, Katie Case and Brianna Coslow, who were very much involved in all of the conversations about like the HR complaints, the girl inviting Justin Baldoni to her hotel room, about Jed Wallace shifting the narrative on social media. Well, they got issued with an order to compel by July 7th. Please be aware that we are rescheduling the street deposition. Counsel for Case and Coslow have indicated a necessary delay in their productions currently ordered by the court to be made on July 7th. As we indicated to the court last week, we need these documents to proceed with street deposition on July 9th. Given that we will not have those documents and also do not have the Street and Wallace party productions or certain relevant documents in Nathan Tag or Abel's productions, we do not have the documents needed to conduct the deposition. We will keep you all appraised of scheduling. So Wallace will not be deposed on July 9th, and in fact that will get pushed out because yet again the TAG employees, Case and Coslow, are delaying production of their material. It also sounds like Wallace has not finished his party productions either, nor have TAG, Abel, and Nathan. Again, seems like a deliberate tactic to hold back depositions and make sure that those depositions are tried to happen without all of the necessary information to hold them. So, oof. Wait, she invited him to her hotel room, not the other way around. Sorry, my lady. Yes, no. Baldoni invited her to his hotel room, I believe. Sorry, you are correct. I apologize if I misspoke. Thank you for holding me accountable, chat. What else was I looking at? I was looking at something there. Not me thinking of the movie with Ryan Reynolds and Sandra Bullock when you said The Proposal. Yes. Oh, I love that movie. It's one of my favorite movies. To the window, to the wall, to the sweat drips down my... I love it. I am a sucker for Sandra Bullock movies, I'm afraid. I love them. I love her as an actress. Is my wife still watching? Yeah. Love you too, baby. But she knows. I have a love of, I guess, terrible comedy romance movies involving her. I don't know why. Just this. But also, Demolition Man is still a very strange and fun movie. I wanted to make sure I wasn't misunderstanding all this time. No, often it is my misunderstanding, not yours. So, all right. So we got all of that. Deposition availability. So let's go into the schedule we talked about there. They asked about this deposition schedule, and what Wayfarer come back with is that Jamie Heath is available only on the 28th or 29th. Justin Baldoni, coincidentally, is only available on the 30th or 31st, right after. Melissa Nathan is only available on August 13th. Jennifer Abel, again, just happens to only be available the day after. And Steve Sarowitz is only available for 2 days on the 5th or the 7th. So obviously, Blake Lively's saying this is unacceptable. And I kind of have to agree, because I don't know if you've been aware, but Justin Baldoni has spent the last 4 months on vacation. He was first in Hawaii for months, surfing. Then he went to Costa Rica, and this last week, I think it was the last week, or it might have been the week before, he was spotted just hanging around Disneyland or Disney World. I forget which one of the Disney parks, just hanging out, walking around, being spotted by randoms. Not one person, but 2 people actually spotted him there. I also saw there was another TikTok video of him getting on a plane to Texas. I don't necessarily know if he was flying through Texas, whether he was stopping off to go give Jed a high five. But Justin Baldoni appears to be spotted quite regularly, just traveling and vacationing. Doesn't actually seem to be doing anything. So it's very strange that he is apparently busy the entire month and is only available for 2 days. So, and like Lively says, it seems very much that they are trying to impose a set schedule of order of those depositions by means of their availability. So there's no way to have Abel go first, or Nathan go first, or even Baldoni go first, because the way that their schedule is set out is that, you know, there's a set order. There's no way to do this other than Heath, Baldoni, Sarowitz, Nathan, Abel last, right? There's no way to do that. And so they appear to be imposing on Lively the order in which these will go in, which again, does not seem right either. Finally, then we go on to the data that they dumped, right? This 100 terabytes that they talk about here that they were sending over as of June 26th, right? Like what, like 5 days, right, before the production deadline. They're like, hey, by the way, we've got 100 terabytes of data. How do you want this? We can give you encrypted hard drives that we can deliver to you, but we need to know which physical office to deliver the hard drives. Or we can use AWS and upload to an S3 bucket, but that's going to take us like 10 days to upload to the internet. And you would think, like, why would you not like have thought about this beforehand and done this? I don't know, right? To say this like 5 days before, like, hey, it's going to take us 10 days to upload this. You would have maybe thought about this. You would have known that you had 100 terabytes of data. So Baldoni's dodging his deposition. Blake didn't reschedule hers. No, Blake did reschedule hers from the 23rd of June to, was it July 17th? But she's doing that because she has asked that she wanted the film footage before her deposition, which they did not provide until afterwards, June 26th. And so now, having provided, like I say, about 5 years of film footage, they're asking her to review that quickly and then do her deposition because, you know, we've given you what you need. So I do think, like I said, I think they talked about 50,000 hours. I do think that's a little high. Shout out to Turtle819 on Reddit, who provided this really good breakdown of the numbers, that 100 terabytes is actually 102,400 gigabytes because of the little extra bit. From the way the bits are calculated, and saying that where Lively's team got this 50,000 hours from is likely based off the 720p standard, which would be about 2 gigabytes an hour, which would give you about 50,000 hours. So that's probably what they're talking about. It is unlikely to be low quality, like 720p data that they're talking about. Chat, if this is going over your head, let me know. Basically, we're talking about like quality of video, right? So the kind of video that Netflix streams at, I think 720 is probably going to be standard def, not high def. So standard definition, streaming video over the internet, lower quality, be about 2 GB for every hour of footage. And that would equate to like 100,000 gigabytes, like 50 hours, 50,000 hours, about that, right? So it's probably not that. They made a guess based off this lower number. Turtle here provides some other numbers for higher resolution video. So Blu-ray, the kind of Blu-ray that you get on it, it is what's called compressed, like a zip file, so that you have all of this data, but it is done in a very efficient space-saving format. And so that is about 10 gigabytes an hour. So that would work out to about 11,000 hours. Other kinds of compression, 4K video. So now we're getting to like really good, like your big 4K TV, right, would be about 14 gigabytes an hour. That works out to about 7,000 hours. And then also some other forms of compression for 4K, 4K max, at 1080 would be 30 gigabytes an hour, 3,000 hours. For 4K high def, about 800 hours. It's also likely that the cameras themselves shoot in an uncompressed format. So that video is going to be many times greater. And it could be that that's what she's gotten, right? So it may be that this actually works out to be something around 100 to 200 hours of footage, if it's uncompressed. But we don't know, right? Until they show us or talk to us about like what it is, which they don't need to, right? Like they're probably not going to unless they file something about it. It could be anywhere between those, right? So it could be anywhere between around like 200 to 1,000 hours of footage. But I mean, 200 hours is still a lot of video to get through, to, review, to understand what that is, to make, documentation about it so that you know where all of the different video is, and especially if you're looking for specific pieces or specific events. So yeah, they definitely kind of overproduced on this, and to do it at the last minute is intentional to kind of bog them down with going through all this video. Apparently this is called a data dump. So I'm told by MJ. And this is a particularly crappy tactic by litigators to essentially dump a ton of documents on the opposing team so that then they are stuck having to bog down and review all of this and delay and overwork them to be able to get through all of this. So this seems like a very bad faith tactic to not produce this video for months, to do it at the last minute, and then to do so knowing that this is hours and hours and hours of content, hundreds of hours, if not thousands of hours of content for them to review, with no time to be able to do it ahead of her deposition. So my lady says, still way too much to go through in a short amount of time. Yep, 100%. I mean, like, fortunately, we're at the stage in technology where, like, we have AI tools and automated tools. I talked on Twitter today about, like, I have a tool where I can throw video into it and it will automatically transcribe it, put it into a database, and I can instantly, look for keywords that are said in certain videos and be able to find them across all videos. It's what makes me so good at having receipts, is having a good database of receipts. But even that process takes time and is expensive as well. So my lady says, I remember the strategy from KL, Korean law dramas. Interesting. I haven't seen that. Is there a particular show that you're talking about, my lady? Mousy Jinx says, unless Batman shot everything, no cameras they use for the Matrix, there's just no way. I mean, that's the other thing to think about, is like, this is probably from 3 or 4 cameras, and if it is from really high def, super high format, like you could easily get to 100 terabytes. I don't think so. Given that Wayfarer kind of penny pinched everywhere else, I don't think that they were sort of, shooting on these insane 8K cameras or anything. I don't know. Like, who knows what they were shooting on? So we'll see. But it could also be, don't forget, like, it could be all of the raw footage, all of the edited version of the raw footage. There were at least 3 or 4 cuts of the movie, so all of the supporting material for 3 or 4 cuts of the movie, and so on. So, like, you know, it could also be the various versions. You know, I've talked before about how Baldoni worked on a version of the cut of the movie when they broke originally for the strike in June, July of 2023, was then working on cuts of the movie through 2024, through like February, April, February, March, April, I think even into May. I think it's not till June he gets kicked off. Um, and there are at least like 2 or 3 versions of the movie that he's working on through that. So like that's where a lot of this could be. It could be lots of duplicates of the same footage, just in different edit formats, styles, color corrections, different stages. So yeah. Uh, but Y says, I've never been in the right time zone before. A big fan, excited to be here. Well, glad to have you. Got you be able to catch some of this. Our scientist says, yeah, I'm betting there's a lot of repetitive footage in there from editing too. Yep, I think so too. I think part of this is a tactic to just swamp her with multiple duplicate versions of it to make it so much harder to find the relevant information. Miley says, I've watched so many Korean law dramas, I can't remember which one. Fun fact, legal and medical dramas are fairly accurate with portrayal of the systems, if not interpersonal relationships. I don't know what you mean. I feel that Grey's Anatomy is a very substantial and accurate depiction of romantic relationships. 100%. Obi-Wan Kenobi says, we saw the raw footage. It wasn't exactly Avengers quality. Ouch. I mean, you're not wrong. Yes. So we'll see. We'll see. And I think Lively's probably after a lot of the footage that she talked about in her complaint that was kept rolling that they were talking about. So we talked about all of that stuff. I don't think there's anything else. So I think that is it for tonight, right? So yeah, so it'll be interesting to see what happens in terms of that. I think they are going to probably grant the extended schedule because I don't really think there's another way. I think Wayfarer will just be dragged along to it, or Wayfarer will be asked to provide their own schedule that they can provide to it. But I think the problem Wayfarer has is it's very difficult for them to object to extending this deadline while at the same time having not produced on the deadline that's are already there, right? Lively appears to have produced. Lively doesn't have an issue with it. Wayfarer don't seem to have an issue with Lively's productions. So it seems like yeah, Wayfarer are just gonna have to get with the program and actually start producing Discovery. But again, like if that is the case where they're going to hold back, it doesn't do anything but hurt their own case. If they don't produce evidence, they can't use it in trial, and it then pushes it more likely to be a summary judgment against them based off the evidence they're refusing to provide. So again, it just seems like they don't want to go to trial. They're trying to make it as painful as possible and delayed as much as possible. And knowing that they're going to go to trial with one hand tied behind their back. I've said this before, I will say it again tonight, like they need better legal counsel because the counsel they have is not a good trial strategy. None of this seems to be putting them in a good place ahead of trial. It really does feel like they think that they can avoid trial or not go to trial. And as we continue through this path, that seems less and less likely that they are going to avoid it. So I don't know why you would be betting on an increasingly shrinking possibility rather than knuckling down and preparing for what looks like is going to be inevitable. So we'll see. Master Jake says, I think Grey's was less absurd. Then I think you need to watch more Grey's Anatomy because that has always been incredibly absurd. Mo says, as a Grey's watcher, I take offense. I just, know this though. Every time I watch Grey's Anatomy, or I should say, every time I'm in the room when Grey's Anatomy is on, because I will never be the person who intentionally puts Grey's Anatomy on the TV. Whenever I am the person in the room when somebody else has put Grey's Anatomy on, mentioning no names, I will inevitably be in tears. I know how the episode is going to end. You know that the person coming in with the terminal illness is going to recover, but the doting spouse who is overly worried about them and pushing the doctors is the one who is going to have a sudden and unexpected death that will rip your heart out from you. And I will always be in tears at the end of the episode. I wish I could avoid it. I know what is coming. I know the plot of the episode. I know how it's going to end, and it still gets me every time because I'm a giant softie. So, yeah. You wanted to add that subreddit is pretty neat. Which subreddit? Which subreddit? The Grey's Anatomy subreddit are we talking about? Call it out. Which subreddit are we talking about? Let everybody know. Mo? All right. So, anybody else got anything they want to say before we wrap up? Because, like I said, I think this is going to be a quick 2 hour, quick 2 hour stream this week. Like I say, we will be back on Sunday, where I'm going to be talking, like I said, about the amicus briefs, but mostly in the context of we're going to talk about what sexual harassment looks like in the workplace, the education around it, what those protections are about being reported activity, what sexual harassment activities look like in the workplace. We're also going to talk about DAVO, what that is, what that looks like, abusive tactics around it, and then kind of tie it into a little bit what they're talking about in those amicus briefs. So, no, Mo says, I meant the Baldoni Files. Yes, Baldoni Files is a great subreddit. Definitely a really good community of moderators that are doing a really good job of keeping things fair and even there. So if you are on Reddit and you want to know more of this stuff and see as we post and learn about these things, those conversations definitely be involved in that subreddit because they're a good group of people. It said, I was reading the rules on it and said it's a place who do not victim blame. So that's very much appreciated. Yes, it was started as a space for victim advocates to come together to discuss this topic. And they've done a very, very good job of keeping that to be a very safe space to do that. So appreciate all of their hard work. I would love someone to address how juries award damages for retaliation versus sexual harassment, but it's a homework one. Yeah, okay. I will think about it and see if we can talk about that by Sunday. I might not have the answer for that, but that would definitely be a good question to ask. And it also might be a question to throw up to some of the legal commentators on this as well to send this up. Marcy Jinx says, I am looking for group for the Davos stream. Yes, I will see you. I will try and make it at a reasonable time. I don't know what time that's going to be yet because I need to get on and finish the script. So I will go get doing that with the rest of the evening. Thank you, chat, for so much for hanging out with me. Thanks, but why? Thanks, Marcy Jinx. Thanks, Mo, my lady. Obi Mom Kenobi, Subtle Murder, appreciate you. Or Scientist, or AU Scientist, we've had this conversation before, but we're having it again tonight. Atticus Silver, of course, Gina Richardson, and the Junk Farm, thank you as well. I think that is everybody. If I missed you, I apologize. But thanks for hanging out. We will do this all again next week. But we'll do it all much sooner at some time on Sunday. So stick around and look out for that notification going up. In the meantime, appreciate you. Have a wonderful rest of your evening, day, whatever it is while you're watching this. If you enjoy the content, as always, like, comment, share it with other people, share that knowledge and information. Yeah, and just, try to take care of yourselves. It's a lot right now. Try to hug on yourself, hug on somebody else, because we all kind of need a pick me up right now. And I will see you Sunday, if not before. Take care, everybody.